highly relevant and highly material to our production of evidence in furtherance of a third-party culpability defense to which Ms. Reed is richly entitled. Your Honor, our request is not a discovery request. Our request is an evidentiary request. That's very different. We are not asking for discovery through the process of seeking Mr. Albert's phone or the phone records associated with Ms. McCabe. We're asking for evidence. Evidence that's material, evidence that's relevant, evidence that's salient to a third-party culpability defense, one that we've already made a good faith showing exists in this case, and this court has already ruled is a relevant and material defense. We ask that the court issue the summonses under Rule 17 for both Mr. Albert's phone and the associated data therewith, as well as Jennifer McCabe's cell phone records and the associated data therewith.
All right. Thank you very much. Mr. Melo, I'll hear from you, and we're also going to hear from Mr. Allen's order, and we're going to hear from Ms. McCabe's order as well. We'll call on you after, so we're going to hear from Mr. Melo first.
Thank you, Your Honor. Your Honor, the Commonwealth request.
Your Honor, I'm sorry to interrupt. If Mr. Lally, or if the court could gently ask Mr. Lally to address the court from the podium, I simply can't hear him with his back turned.
I can hear you.
Understood. Your Honor, the Commonwealth requests that the defendant's Rule 17 motion be denied. This isn't a situation where the Commonwealth is afraid of evidence being produced or desperately afraid it's characterized. It's simply that the counsel and the defendant need to comply with the rules and need to actually state actual facts and actual evidence as opposed to the fanciful facts section that's been submitted to the court. This case does not, as counsel suggests, hinge solely upon the testimony of Ms. McCabe. The statements and testimony of other witnesses, forensic evidence, video evidence are conjunctively simply hard to reconcile with counsel's facts, even assuming everything appeared in their motions and affidavits true and accurate, which I submit that it's not. The predominant amount of statements made by the defendant to this witness named Ms. McCabe were made by the defendant in the presence of additional witnesses, which is conspicuously absent from counsel's recitation. Counsel states in the motion that the defendant had always maintained a purported story for leaving Mr. O'Keefe at the Fairview residence and calling him repeatedly to ensure that he was safely within the home. The defendant, over the course of the investigation, said a lot of things to a lot of people. She talked to a lot of civilians, she talked to a number of troopers involved in the investigation. This story was never presented, not once. She did present varying accounts to varying people as far as when she last saw Mr. O'Keefe, what happened with Mr. O'Keefe the last time that she saw him, but never this particular version of events. The defendant seems to suggest that the body of Mr. O'Keefe was discovered that morning by the defendant and Ms. McCabe. However, Ms. Roberts was present with him at this time as well, but remains absent from counsel's recitation of the facts. Counsel further states that Ms. McCabe inserted herself into the defendant's search that morning for Mr. O'Keefe. However, it was the defendant that awoke the victim's niece at approximately 4:30 in the morning, had the niece repeatedly call and text Mr. O'Keefe, and then asked for or instructed the niece to call Ms. McCabe at 4:53 in the morning. So this suggestion that Ms. McCabe is up all night pacing around her bedroom, or that she's shockingly awake at 4:53 in the morning and answers this long call from the defendant. She answers the call from the victim's niece, and then the victim's niece, at the instruction of the defendant, puts the defendant on the phone. And that is how this search or how this issue begins. The defendant initially tells Ms. McCabe that she last saw the victim at the waterfall. When she's then subsequently informed by Ms. McCabe that she had seen Mr. O'Keefe and the defendant leaving the waterfall together, and further seen the defendant's vehicle in front of the residence on Fairview, the defendant then indicates that she left Mr. O'Keefe on Fairview after they had gone into an argument. These aren't just statements that Ms. McCabe testified to. These are statements that the niece overheard while Ms. Reed was talking to Ms. McCabe on the phone. She provided an interview and indicated and corroborated those statements Ms. McCabe attributed to the defendant. The delay that counsel appears in the motion that Ms. McCabe caused in Ms. Reed's frantic search of trying to get to the residence on Fairview, the evidence demonstrates from Mr. O'Keefe's ring video that the defendant left Mr. O'Keefe's driveway at approximately 5:08 in the morning from the ring. She does not arrive for approximately half an hour later at Ms. McCabe's home, and the information from her phone and And the information from the video from the Kansas Public Library indicates that during that time frame, she travels towards the waterfall. She travels in the direction of the Fairview residence. So any delay that was caused in her getting to that residence with Ms. McCabe and Ms. Roberts was her own doing, and not that of Ms. McCabe. And the defendant also states that Ms. McCabe stated to Trooper Proctor that while they were searching for Mr. O'Keefe, the defendant repeatedly asked, "Did I hit him? Did I hit him?" The defendant also repeatedly stated this when the body of the victim was discovered, as reflected in the testimony of Ms. McCabe. It's also reflected in the testimony of Ms. Roberts. It's also reflected in the testimony of the first responders, paramedic who was standing directly next to the defendant when she said these things in response to the paramedic's questions. The further statements that Ms. McCabe attributes to the defendant while he was driving around were also corroborated by Ms. Roberts, because Ms. Roberts is on the phone with them on a Bluetooth while Ms. Roberts is driving her vehicle and Ms. McCabe is driving Ms. Reed's vehicle from Ms. McCabe's house back to Mr. O'Keefe's house. So all of these statements that Ms. McCabe has purported to have created are corroborated by other witnesses, by video, and by forensic evidence. The new revelations and the new evidence that counsel fears was withheld from the defense, Mr. Green had apparently uncovered, is speechless at best. It's from the affidavits or the reports that were subsequently done by Trooper Reno and an independent forensic experts our office hired in regard to this, whose qualifications are contained within the attachment that I filed with the court, approximately a 21-page resume that she has in this particular field. She teaches in this field, she writes in this field, and she comes to the same conclusion that Trooper Reno does, that those Google searches that are attributed by Mr. Green attaching at 2:27 and 40 seconds in the morning did not occur at that time. They were a result of the file being parsed from a headlog or a wall file. The analogy that I would make as far as Mr. Green's analysis of the phone is very similar to counsel's recitation of the facts. It shows you one thing, but neglects to put it in the context of the rest of the facts. Neglects to put it in the context of the remainder of the evidence. And what Mr. Green does is, yes, there is an indication in the phone that there was a search at 2:27 and 40 seconds in the morning. However, if you look behind that data as to when that entry was actually created, it's 6:23 a.m. and 6:24 a.m., which is while Ms. McCabe is on the scene in front of the Fairview residence with the defendant, conducting that Google search in response to the defendant's request to conduct that Google search, or the Google hypothermia or something to that effect. As far as these deletions within the phone, both forensic experts, being Trooper Reno and Ms. Hahn, indicate that these deletions are not something that is actively done by the user. So to simply say, oh, this information was deleted from the phone, is not an indication that Ms. McCabe deleted that information from the phone. It's something that happens as data is stored, as data is set aside. Two such things as this wall file. There is a search at 2:27 and 40 seconds in the morning. It's in relation to Ozone basketball. Now, Ms. McCabe also testified that the night before going to the waterfall, her and her husband had gone to one of her daughter's high school basketball games. She indicated that her girls play basketball, girls play sports. She's checking scores, she's checking standings, she's checking stories about her child's basketball game at 2:27. Essentially, the best way that I can describe it, if you were to open up the Safari app on your cell phone and you engage the Google website and you do a Google search, then you close that Safari application, you put the phone down on the desk for 6 hours. You pick up the phone again after that time has elapsed. You go back to the same Safari tab, and you go back without creating a new tab or a new website. You go back and do a subsequent Google search. That subsequent Google search that you're doing at, say, 6 p.m. is going to reflect in the phone as being done when the website was first visited, when Google was first visited, that's 6 hours before. That is what happened in this particular case, and it's borne out throughout the affidavits and reports from the various forensic experts in relation to that. As far as the phone calls to the outlets from in front of the house, yes, there are phone calls reflected in the phone. There's no deletion of Mr. Brian Albert's contact information from within the phone. It's still in the phone. It was in the phone when Trooper Reno did the extraction on May 4th of 2022. It's still in the phone now. The phone calls, I think, are perfectly sort of understandable in the sense that Ms. McCabe was in front of her sister's home, finds her friend lying on his back, struggling for his life, and she makes a phone call to her sister. The phone calls durations, they do list as answered, but so do calls when they go to voicemail, they list in the phone as answered. And the duration of the calls, I think, is telling. And that the first call, at 6:07 and 42 seconds, lasts for a duration of 9 seconds. The second call, 6:08 and 17 seconds, which also lists as answered, lasts for a duration of 7 seconds. These are calls that are going to voicemail. And then subsequent to that, at 6:23, Ms. McCabe makes a phone call to the Brian number, which lists as unanswered. The last, as far as the health data, I don't want to keep reiterating this, I spoke about it in the last court date, but the health data for Mr. O'Keefe's phone has him taking 133 steps at 8:08 in the morning, 68 steps at 8:25 in the morning, 87 steps at 7:57 in the morning, 81 steps at 11:06 in the morning, 109 steps at 11:18 in the morning, and then 46 steps at 11:56 in the morning. The issue with that, as far as being able to rely on any of that data for anything whatsoever, is that Mr. O'Keefe was pronounced deceased in the Samaritan Hospital at 7:50 in the morning. So all of these steps, all of these feet, all of these things that he is traveling are after he is passed away. Furthermore, as far as the 3 floors going up and down within the house, in Trooper Garrido's report he details as far as looking a little bit deeper, a little bit more than just, oh, the phone or the health data indicates that he went up or down 3 flights of stairs. What it also indicates from Mr. O'Keefe's phone from the GPS information is that he did a wave search because he had never been to 34 Fairview Road before. He does a wave search to try to locate it. Now that GPS information from his phone has at the same time that he's going up and down 3 flights of stairs, he's more than a half mile away from the residence at that particular time. It also gives speed. He's traveling at a certain distance, meters per second, that's encapsulated within the Trooper Garrido's report as well. None of that health data is even remotely accurate. Now, furthermore, there is a supplemental report which I filed as an attachment to the Commonwealth's opposition to Trooper Garrido conducted in regard to certain measurements and GPS locations from Mr. O'Keefe's phone. And what they show is sort of concentric circles as far as the distance that a person could travel from that in those specific time. Essentially what it boils down to is there is a total of 3 seconds. 3 seconds. The entire time that Mr. O'Keefe is in the area of 34 Fairview Road, that any of those concentric circles even touch the house of 34 Fairview Road. Following immediately from those 3 seconds, the circles are able to then be condensed and more accurate information is generated in relation to putting him exactly where he was found at 6 o'clock the next morning by Mr. McCabe, the defendant, and Ms. Roberts. Another statement attributed to Mr. McCabe is that Alex Reed was the only one who could see in the blizzard conditions, which I know the court has reviewed in relation to Officer Sharaf's cruiser camera footage of his approach and arrival at the scene, which is almost around the same time as the 3 ladies would have been approaching 34 Fairview. But the point being, again, is the statement that Mr. McCabe was the only one who said that the defendant said this, or the only one who described his reaction by the defendant as being the only one who could see Mr. O'Keefe laying in the snow, covered in snow from that distance in the dark and blizzard. Unlike in the recitation of counsel's facts, Ms. Roberts, who was in the vehicle, said the exact same things. And I think one of the other things to note is that these 2 women, as far as Ms. McCabe and Ms. Roberts, essentially barely know each other at this particular time. So how they are related to his niece and how they are related to Mr. O'Keefe is Mr. O'Keefe cared for his nieces. Now, Ms. Roberts has a son around the same age as Mr. O'Keefe's nephew. They both Ms. Roberts and Mr. O'Keefe grew up in Granger, knew each other in that regard. Ms. McCabe has a daughter and lived in the general vicinity initially where Mr. O'Keefe lived when he took over care of his children. His niece is around the same age as one of Mrs. McCabe's daughters. Different ages, different genders, different kids. They barely knew each other before this day. And now they're sort of inextricably linked going forward based on their shared experience of being called and told different stories by the defendant on this particular day and taken on this ride along to discover the surface. The revelations from the forensic expert, Mr. Greenwich, is the only thing even closely approximating new information from the prior 17 motion that was denied in relation to this. There's species. None of that information based on the further, it's similar to the arguments that are made in relation to the facts. If you take one piece of evidence, divorce it from context, and don't provide any sort of contextualization of what that means within the whole of someone's part. And the same thing is being done as far as the affidavit from the forensic expert is taking this thing and saying, oh, well, there's a search and it's deleted. But if you look at the search, look at what deleted means. It doesn't mean what counsel says it means. It doesn't mean what counsel reports it means. For those reasons, I've asked for the motion.
Thank you, Your Honor. So you've heard for 40-something minutes
different recitations of facts. I want to focus for a moment for the Rule 17 just on my client and the allegations that the defense has made. Even after you bottle up everything that's been said, the allegation is that someone, not my client, placed a phone call to my client that went unanswered after the body had been discovered in the front yard. That's the sum total of the allegations from defense that touch on the issue of the phone. The rest of the material that the defense has suggested is relevant to their Rule 17 is theory, and I would argue it's the alternate theory, and they're entitled to make their alternate theory argument. Mr. Jackson a few moments ago used the phrase safe harbor in relation to the concept of fishing expedition, and he actually stole the words that I was going to use in relation to the concept of third-party culprit. Because really what that boils down to here is the defense is saying we get to do whatever we want, search high and low, do whatever we need to in order to defend our client. And I understand in concept what that means. But the issue is that under the provisions of our law and the case law, they can't just say it's relevant to their case, snap their fingers, and then go into the personal effects of a third-party innocent person who's related to the case only because they're a witness. But that's the argument that they're making. The only connection between what they're suggesting and my client's phone is an unanswered phone call. Unanswered at 6:23. Counsel made the suggestion, and I said earlier that there's never any indication or record of phone communication. That's not what I said in my opposition. I said there's no indication of a conversation because there's zero grand jury testimony about it, there's zero forensic evidence about it, there is no conversation because one didn't take place. But that's the suggestion they're using to then bootstrap the rest of the argument. The federal rule is guiding Massachusetts case law. There's a federal case that came out in 2018, United States versus Cartagena-Albadalejo. And in this case, there is a Rule 17 subpoena that is issued by the defense seeking, quote, exact copies of the reports, photos, or notes regarding a shooting incident on a particular date. The court made the comment in ruling against the Rule 17 decision that request, just for copies of notes and photos or reports, was overly broad. Quote, the potential to bolster a complainant's allegations and the potential to undermine them provide possible material for impeachment, but the inability to articulate with precision what records he seeks or the purpose for which he seeks them confirms that he cannot satisfy the specificity of them. If the moving party cannot reasonably specify the information contained or believed to be contained in the documents sought, but merely hopes that something useful will turn up, this is a sure sign that the subpoena is being misused. Moreover, they have cited no authority to support the proposition that searching for, quote, alternate theories is a proper basis to compel production of documents. And that is precisely what we're dealing with here. The defense has a theory. I give them that. That's their job. But the Rule 17 standard does not allow that they snap their fingers, come up with a theory, and then intrude on other people's personal, private materials in order to then build their case. Because the concept there would mean that, again, talking about one phone call. So let's use this in some other case, because if the court were going to make this ruling, it would stand for a proposition. The proposition would be that if a witness to statements and a witness to conduct of the defendant makes a phone call, any phone call, the person that that witness contacts has to turn their phone over to the defense if they want to create an alternate theory of the case. And that cannot be what Rule 17 stands for. This case, the federal rules, the state rules, they outline the standard that the defense needs to meet. And if you look at the actual Rule 17 that they filed, what they're requesting is far more broad than, quote, reports, photos, or notes. They're requesting a 7-day period of everything having to do with the phone and the phone itself. That overly broad interpretation of Rule 17 is reflective of what the defense theory is here. The defense theory is we have an alternate defense. We want to argue and create evidence for that alternate defense. And that is not what Rule 17 is designed for. Because Rule 17 isn't about her. Rule 17 is about the third parties. It's designed to protect those people who, by no fault of their own and no conduct of their own, become involved in the matter, either as a witness or a bystander or what have you. That's exactly what's happened in this case. And so rather than trying to meet the burden, after hundreds of pages of affidavits supporting documents, what it boils down to is a phone call that was placed and never answered and no communication. And they're trying to use that, plus all the other window dressing, to suggest that that allows the court to order a subpoena for a third party to turn over their personal effects. And that is not what Rule 17 stands for. I just ask that the court take this into consideration, even though it's not part of the opposition memo.
Mr. Jackson, I'll let you recently
You know, I could cut to the chase in my mind and system here. I defer to the court's discretion on this portion of the motion. This was basically directed to
Thank you very much. All right, Mr. Jackson, so go ahead and continue.
Thank you, Your Honor. With regard to the Commonwealth's argument, taking those in order, to reuse the same word that's been used and probably beaten to a pulp today, talk about a regurgitation of the same tired, factually incorrect theory. That's exactly what you heard today, was exactly what Mr. Lally has been reciting. He literally read it from a paper that was clearly had for some time. It's the exact recitation of the same facts that he's used over and over and over, and they are factually incorrect. He indicates none of the facts that we've cited in our moving papers are supported by any evidence. That's absolutely incorrect. That's absolutely incorrect. For instance, Jennifer McCabe. He said Jennifer McCabe was not up all night. There's no evidence whatsoever that Jennifer McCabe was up all night, except for her Apple Health data, which shows that she was up all night. We didn't make that data up. That data came right from a cell phone extraction that was conducted in no small part by their own expert, and then reconducted by our own expert. How about the fact that she was actually on the phone searching? The Safari data establishes that not only was she up all night, but that the phone and Safari was being manipulated during those times, at 2 o'clock, 3 o'clock in the morning. These are unassailable facts, unassailable data, directly from the Cellebrite extraction. These aren't, as Mr. Lally likes to say, fanciful facts. He's got that written down somewhere, obviously. He said that at just about every hearing. There's nothing fanciful about any of the facts that we've submitted and is supported with affidavits and evidence. The Commonwealth's theory, quite to the converse, is supported by nearly nothing. Nothing. Everything that we've suggested is supported by the data, the evidence, and the facts. The Commonwealth's theory is supported by conjecture and really bad policing. Almost unbelievably and very troubling as an officer of the court. Mr. Lally provides a brand spanking new expert yesterday. We didn't have any of the information concerning this new expert. Quite frankly, I haven't even committed her name to memory yet. I don't even know it. It's Jessica Hyde, H-Y-D-E. First time I've ever heard of Jessica Hyde was yesterday while I was on the plane on my way here. That's when we received that information. And lo and behold, Mr. Lally springs that on us today and starts reciting her factual conclusions and opinions. That is wildly inappropriate, wildly unfair. We haven't had an opportunity to look at her report, to review it in detail, to have our expert compare his notes to her report. What I will tell you is that what Mr. Lally said about her report is not quite true. He didn't quite get that right either. What she actually said is why the timestamp is listing the time of 2:27 and 40 seconds in the morning is unknown. Her words, not my words. That's what she said about the timestamp. That her conclusion is the reason for the definitive timestamp is unknown to her. Well, we know why it is, because we've had more time to distill it. There's something, and I'll take this opportunity since Mr. Lally brought it up and tried to explain what his theory, an incorrect theory of the timestamp is. I'll take a minute to explain what the actual true facts are. An Apple iPhone has a clock in it. It actually has two internal clocks. One of those internal clocks is run by a program known as Apple COCOA core time. The Apple Cocoa core time is the number of seconds from January 1st, 2001 until right now. So for instance, if I open my phone, which I just did, Apple Cocoa core timestamp just noted the exact moment that I just opened my phone. And it's noted from January 1st, 2001. Right now, actually in 2022, in January 2022, those numbers of seconds was around 665 million. About 665 million seconds had passed between January 1st at midnight, 2001, to January 29th, around midnight, around 2:27 in the morning, on January 29th, 2022. Why is that important? Because their expert, Mr. Garino, indicated, oh, well, you can't rely on the timestamp of How Long to Die in Cold, because that's at the exact same time as the Ozark basketball webpage was brought up. So something must have gone wrong. I don't really know what it was, but it must have been something. Well, what we would do, had we had an opportunity to cross-examine Mr. Guarino, is perhaps to explain to him that which he doesn't know, which is the following. More than one web page can be up and open on a cell phone at any given time. The court knows this. Everybody who owns a cell phone knows this. You can have multiple pages open. One page is sitting on top of the other, and then there are multiple pages behind it. All those pages are still open and potentially running in the program, in the iPhone. The 227 How Long to Die in Cold search was nanoseconds, milliseconds, before the Ozark basketball search page came up. How did Apple Cocoa Core Time relate those two events, those two artifacts on the phone? It happened like this. At some point, she searched, used her thumbs. The Apple iPhone doesn't coordinate the timestamp for when she's using her thumbs. People type faster, people type slower. It coordinates when someone exits out of a search. In other words, when you close that web page. She obviously Google searched How Long to Die in Cold. We know that because we found the search. The deletion was not the deletion of the search, it was the deletion of the page. And as soon as that page was deleted, the other page behind it, Ozark Basketball, was immediately populated. And when I say immediately, not at the same time, nanoseconds behind it. We actually have the nanoseconds. It's 5 digits beyond the decimal point. We know exactly how that happened and why it happened. And Rick Green, our expert, has verified that, not through one, not through two, but 5 different tools, establishing exactly how long it took for the Ozark page to populate behind the How Long to Die in Cold page once Jennifer McCabe exited out of that page, if that makes sense. So we know that she was Googling How Long to Die in Cold at minimum, 3 hours before John O'Keefe's body was ever found. This is not some anomaly. It's not a question. It's not, as their new expert says, unknown why the Google search took place, or the timestamp is what it is at 2:27:40. We actually know. Rick Green knows. His colleagues know. And the scientific community knows. Mr. Lally also said, Jennifer McCabe, she didn't delete anything. This stuff just happens. Well, stuff just doesn't delete itself on an iPhone. Everybody that has an iPhone, every 4-year-old that has an iPhone knows that stuff doesn't just delete itself. That's not how iPhones work. Everything that was deleted was concentrated into a time period. It was concentrated on or around January 29th, 2022, at or around 6 a.m., 7 a.m., 8 a.m., throughout the day on the 29th, and up until she turned that phone in on February 2nd, 4 days later. Those deletions weren't coincidental. They were done by her. 18 separate calls were deleted. There were 7, by the way, and I will address counsel's statements about Brian Albert and his phone in just a second, but it dovetails into what I'm saying right now. In terms of the conversations that counsel talks about, what he said was there was no conversation between Brian Albert and Jen McCabe on the 28th or the 29th. He's just wrong about that.
You wrong.
Just ignoring the facts.
You wrong.
There were 7 phone calls.
You wrong.
One of them, at 6:24 a.m., was unanswered. The other 6 were all answered.
You wrong.
And there were conversations. They were in some cases not just seconds, but minutes long. So there is evidence that McCabe and Albert were communicating back and forth to one another. That's why it's important that we verify what those communications were and how long they took, and what other communications might exist on Brian Albert's phone that weren't sanitized by Jennifer McCabe before she turned her phone into the authorities. There were also phone calls, not to Brian Albert, but to Nicole Albert, 6:03 and 6:04 in the morning, that lasted 9 seconds and 7 seconds respectively. Those calls were answered. Brian Albert's call wasn't answered, but previous to that call that Brian Albert ignored, 2 calls to his wife. His wife who would be sleeping next to him at that time. Now 9 seconds and 7 seconds isn't very long. It's not long enough to say, oh my God, you guys get up, hurry out here. We just found John O'Keefe's body in your front lawn. It's not long enough to say that and to have a conversation about that, but it is long enough to say something like, listen, we're here, don't come outside. It is long enough for that. And in fact, as we know, Nicole Albert and Brian Albert, a sworn police officer, never came outdoors even though the entire world of law enforcement and medical personnel and first responders were responding to his front yard where a dead body was. Never ever came outside. Interesting. Mr. Lally talks about the 80 steps. He said this at the last hearing, and he said it again and reiterated it again at this hearing, in terms of John O'Keefe's Apple Health data, trying to throw sort of this murky explanation into the mix that the steps actually occurred after he was already pronounced dead. There are obviously, his expert found him, our expert found him, there are data that suggests the steps were taken with that phone after John O'Keefe was pronounced dead. Those aren't incorrect data. That was incorrect policing. It was sloppy policing. Those aren't John O'Keefe's steps. He was laying in a hospital on his way to a morgue. God rest his soul. Those were Michael Proctor's steps. He clearly stuck John O'Keefe's phone in his pocket and started walking around. He didn't secure the phone properly, so the phone was still recording data. It doesn't know whose pocket it's in. So the steps that were after John O'Keefe was dead doesn't mean that the steps were incorrect or it's unreliable data. It means that it was in a different person's possession, Michael Proctor's possession. And that's his fault. Like I said, he just didn't secure the phone. With regard to Kerry Roberts, Mr. Lally just makes this pronouncement, as the Commonwealth is wont to do, just these factual pronouncements with no fact to support it. Kerry Roberts and Jennifer McCabe, quote, barely knew each other. You know, we have 15 phone calls, 15 phone calls on the 29th between Jennifer McCabe and Kerry Roberts. Barely knew each other? If that's true, they got to know each other real quick. With regard to the statements made by counsel on behalf of Mr. Albert, again, he indicates that no conversation. What I said in my papers, Your Honor, was there was no conversation, no evidence of any conversation between Brian Albert and Jennifer McCabe. Therefore, there was one unanswered call. That's all you should look at. Everything else is just cannon fodder. Just ignore it. How about the other 7 calls that were made and answered on January 29th between Jennifer McCabe and Brian Albert? He indicates that we lack specificity in our request. Your Honor, I have nary seen a more specific request ever. We have narrowed our request down to only communications and location data for Brian Albert's phone, and only for the time period between January 29th and February 5th. It couldn't be more narrow, it couldn't be more of a specific request. We're not asking for a free-for-all search of his phone. We're looking for communications and location data only, and only for the time period relevant to his involvement in this case. One of the things that counsel suggests is that the defense is entitled to put on whatever defense they want. We can have a third-party culpability if we wish, but we're not allowed to just go and pick and choose and just throw a dart, pick someone out randomly to invade their privacy. Well, first of all, we're not invading anybody's privacy. We're defending someone accused of murder. And we didn't just pick randomly. Brian McCabe is the owner of the home in front of on whose property a Boston police officer took his last breath. He was murdered and lay in that front yard of Brian Albert's house. Brian Albert is the owner of that house, and he was one of the last people to see John O'Keefe alive. Literally with him just minutes before his death. Minutes before his death. He owns a home with 3 stories. We have evidence that just before his death, John O'Keefe took steps suggesting 3 stories, up or down. We don't know which. He owns a dog. We have specific evidence. Talk about specificity. Specific evidence from one of the country's leading pathologists indicating that John O'Keefe's arm was mauled by a dog. Brian Albert's dog is a 90-pound German Shepherd. Oh, and by the way, Brian Albert made sure to get rid of that dog in the months following John O'Keefe's death. After that dog had literally been with the family for some 7 or 8 years. The person that found the body along with my client, Jennifer McCabe, was frantically calling into the home, within minutes of finding the body. Those calls were later deleted.
It's meeting the man of my dreams, and then meeting his beautiful wife.
Brian Albert later sold the very house where this crime took place, distancing himself further from the crime scene. The Albert family is also connected to, as we've gone into pretty specific detail, connected to the elite investigator in the case, Michael Proctor. Your Honor, I'm bringing up these facts, which the court knows, but it bears repeating only because Mr. Lally and Mr. Higgins have suggested that we just sort of pick somebody out of whole cloth.
Did you hear it?
To seek their information. That couldn't be further from the truth. Brian Albert is integrally involved in the death of John O'Keefe. He is implicated in the death of John O'Keefe. Jennifer McCabe is equally implicated in the death of John O'Keefe and the subsequent cover-up of that death. We are entitled to defend our client. It couldn't be more specific, our request. It couldn't be more narrowly tailored.
Beneath my skin.
And we couldn't need it more. It couldn't be more necessary for Karen Reed to defend herself. She's entitled to this information.
Left defenseless, nowhere.
She's constitutionally entitled to defend herself, and she's constitutionally entitled to this information. Your Honor, there's no question that we have sought to and have successfully narrowly tailored our request. To the court's satisfaction, we are not on official information. We've sought very narrow data from Brian Albert's phone. We've sought very narrow data from Jennifer McCabe's cell phone records. We're entitled to that data. We're entitled to verify that which we know to be true. We can't just walk into court, Your Honor, at a trial and start spewing things that we think might be true. We know them to be true. We have to have evidence to back those statements up. You know for sure that the Commonwealth is going to say, if we don't get these data, where's the evidence, folks? I can see him standing in front of a jury right now. Where's the evidence? Sounds to me like the defense is on this fanciful journey, trying to convince you of facts that they can't prove. We need to prove it. We have the ability to prove these facts. And that's why we're asking for these products, these things, and these records. I'll submit.
Her transmission burns.
Alright, thank you very much. Jim, I think we need next week.
Something in July, we can file further motion.
I'll take this under advisement.
Her transmission.
Do I have to reach out here? Do you want to do a schedule conference? Something in July.
And it can be done by Zoom, Mr. Jackson.
I'm sorry, Your Honor.
It can be done by Zoom. I know I told you to do it, or you can tell us how here.
Understood. Thank you.
Horrible things. The dark inside me from the other place. I won't go back there. I won't.
If September's better for you, we can do that.
I'd really like to do it in July if
Okay, so
possible.
let's do it.
Did you hear it?
Her transmission burns.
We do July 7th? No. 17, 18, or 19 of July, I was looking at. I just can't do that in July.
What about the following week?
Yeah, I'd like to do 11, 12, and 14.
No, I said the following week after the 18th.
After that.
So the week of the 24th,
Of June?
July.
Yeah, just not the 27th.
July 25.
Her transmission